Hello, everybody. Thank you very much for being connected. I hope you can receive us clear. Any sign from you entering into this room. We are very happy to welcome you for this series of webinars dedicated to the EU Digital Omnibus Package. Why did we start this year with the series? Because this is quite a complex reform involving various regulations, lots of regulators, any sector in any European country, addressing questions that were long-standing complex questions, and with the ambition to solve or simplify some issues, dealing with various chapters of the EU Digital Regulation, the AI Act, the GDPR, the Privacy Directive, some procedural questions, some principles or core definitions, especially dealing with the GDPR. And to address these interesting questions, dividing in 3 episodes was maybe a good format for you, us, and anybody, in fact, to introduce and then deep dive the various chapters of the EU Digital Omnibus. And for that, we've been asking experts from various countries, various sectors to address these interesting targets and ambition of the EU Digital Omnibus Package. I will introduce them while we go through the evolution of this webinar, and maybe to make it clearer, the expert of panels comes from various backgrounds, as you can see, and you will have some clearer topics that we will address in the draft agenda we have here. And we'll start maybe with the political context in which this EU Digital Omnibus Package has been popping out from the European Commission. In order to start, I would be very pleased to welcome with us Luca Bolognini. You will have 2, I would say, sparring partners to address this very first topic of our webinar today. My question would be very candid. Why are we there discussing this reform, dealing with recent texts or older ones, addressing different issues? And where do we stand in terms of legal instruments and agenda? Luca, you are a great expert, having an academic background, also a very practical and practitioner practice. So could you please provide us with this first approach about the framework and the momentum of this reform?
Yes, thank you very much, Etienne, for having me here. It's a pleasure. Why are we here in this process, witnessing this proposal to amend, to innovate the digital regulation and the data protection regulation, and also the AI Act in perspective, and the data regulation in Europe? Since many years, we have established a robust framework protecting individual rights, protecting data, personal data in Europe. And we have been adding safeguards to protect individuals, human beings, data subjects, consumers, users, and so on and so forth in the European Union. But in parallel, during I would say, last decade, we also witnessed that this framework, this hyper-protective framework, a noble framework, was somehow unbalanced. Why? Because it was many times overprotecting specific rights not balancing these rights, not balancing enough these rights with other rights, freedoms, interests, also public interests, not only legitimate and private interests. And despite the fact that, for instance, Recital 4 of the GDPR refers to Article 52 of the Charter of Fundamental Rights, and I would add also a reference to Article 54 of the Charter of Nice. Despite this, we witnessed a trend, the trend to overweight, this is my point of view, certain data protection rights in their balance, with other rights, freedoms, and interests, as I mentioned. This aspect, this imbalance, became more and more difficult to manage in a global scenario which is competing and running, basing almost everything on data. The data-driven economy, the data-driven society, the data-driven world, and AI is part of this data-driven world, implied a different velocity, I would say, among countries, among companies, between European companies and non-European companies. And in fact, the problem, the issue was that trying to overprotect certain rights, that is, again, I repeat, a noble objective, we were risking to lose the train and the track of innovation and of competition at the global level. The US and other countries, of course, also Asian countries, are running a lot, using data massively, not considering that much all the safeguards that we are taking into account in Europe. And I'm not saying that this is the right way. And
this is a reality.
Of course, I'm simply considering the facts, the scenarios. And Europe is risking to lag behind in this race. The European Union and the policymakers and the European Commission, first of all, seemed to understand progressively the issue. And the policymakers tried in Europe to deepen the issues and the possible solutions. We had two reports that are very relevant, the Enrico Letta's report and the Mario Draghi's report, almost 2 years ago and 1 year and a half ago, indicating possible directions in order to overcome these burdens, these blockers in certain cases. And many points in these reports were just about the need for a rebalancing work, rebalance among freedoms, rights, and in particular data protection, and not only talking about digital competitiveness. The days and the months passed until the November 2025, And on the 19th of November, the European Commission published its proposal, the Digital Omnibus, including a number of measures, of possible measures. In this proposal, we have also the idea to postpone the AI Act application for certain parts, but there are several proposed amendments to very relevant regulations, not only in the sense of better harmonizing data-related regulations, the data-related regulatory framework, but also amending significantly the GDPR. And this was quite surprising, in my opinion, and a courageous step taken by the European Commission. I must confess that I feared before a weak proposal, weak amendments to the GDPR. While reading the Digital Omnibus, and we will go through some specification of such amendments later, but reading it, the surprise was that there were and there are some bold proposals.
You did not expect such a depth?
I didn't expect such bold amendments. In certain cases, I disagree. I'm not that willing. In other cases, of course, I have my personal book of dreams, and later we can discuss about it and the list of possible amendments which are not included in the Digital Omnibus. But I'm positively impressed by the proposal. Now, the journey, and I will leave the room also to our colleagues, but the journey is very long and dangerous for this proposal. The European Commission will have to convince both the European Parliament and the Council of the European Union, and we know that this can be very, very hard, particularly talking about the GDPR amendments. The GDPR is almost a European constitution, someone said. And so it became, at least, it was interpreted sometimes like a constitution by independent authorities in particular. So let's see. We will see whether the journey will succeed, and the European Commission will convince the other two institutions to approve such or something similar, or even better, with other measures added, this Digital Omnibus proposal. The timing is tight.
What is the ambition in terms of timing?
The ambition is to arrive to the approval during spring, summer. Otherwise, it would.
And this year, you mean? It's almost a joke.
It seems to be a joke, but because
it's serious.
You know, to be in time, we should really run, and I don't know, and I think, frankly, I don't think that it will be possible. But if certain measures will have to arrive, they will have to arrive. I'm thinking about the AI Act moratorium. We will have to arrive before August 2026. Is it science fiction? Probably. Anyway, the process is ongoing, and in my opinion is very relevant and precious, and again courageous. the fact that the European Union had and has to change some rules, to rebalance, to consider innovation, to consider sustainability, which is linked to the possibility to use data, and to this linked directly to secondary use of data, data valorization, to many other aspects, and we can discuss about these later, was so clear, and it is so clear. And it's not about, and it's not because of Trump or Xi or other leaders around the world that we are embracing this approach. So I'm happy to discuss with you and with Carolina and with Stefan and with all the colleagues about also the specific points. But again, I look with favor to what is happening now.
Thank you very much, Luca. And Carolina, since you are the Director of Digital Policy of the Confederation of Swedish Enterprises, SMEs, your role as a representative of trade may have been surprised. What was your first reaction reading the text? What would be your input about the timing? And do you see any need or answer coming from this initiative to issues that were identified before that may be addressed through it, regardless of the uncertainty of the end result? What is your input on this approach from the European Commission?
Well, thank you. Thank you for having me. And thank you for all the very useful and good introduction of my colleague here in the panel. My first reaction, and I mean, from a business perspective, businesses have for many, many years flagged that regulatory burdens, and especially maybe the complexity that comes with them, that is so burdensome when it comes to it's an obstacle for both investments, productivity, but the worst thing maybe is that it hamper and hinder innovation. So I can just reflect that this is very welcome, not least due to the fact that more than 60% of the EU companies, when asked, say that regulatory obstacles are a key problem for investments. And for my confederation in Sweden, we represent 60,000 member companies in all sectors.
Wow.
And nearly 99% of them are SMEs. And the SMEs, that is the backbone of the business community in EU, and they are particularly affected. So when Mr. Draghi and Mr. Letta wrote in their reports about
Competitivity,
the importance of making less administrative burdens and simplify legislation, and that's mostly welcome from our perspective, of course. And I think it's very good also to know that the European Commission has, as a response, I guess, to those reports mentioned, they did this plan for Europe's sustainability, prosperity and competitiveness. And one of the points there is that the plan includes to make business easier and faster. And this is so needed. So just to conclude that part, the reaction was very good, and we are very positive. But at the very same time, I mean, when it comes to competitiveness, they could have gone much more far, I guess, and that is the first reaction. But now we maybe have had a focus on the AI Act and the GDPR, but all the data regulations are, of course, very, very important, and absolutely the overlaps that they also try to deal with in this digital omnibus. So that is welcomed. You asked me about the timing, didn't you?
Yeah. Do you believe in this, I would say, counterclock mechanism where there is a kind of a bargaining between the August 2026 issue about a new chapter of the AI Act or or some other chapters of this omnibus package, time-wise, since you have a good experience of legislation debates and discussions. What is your hope?
But about the timing, I mean, the timing of the package or the digital package and the omnibus is, of course, it's shamefully is maybe a strong word, but that we need to do this within EU this soon. I mean, the Data Act and the AI Act hasn't nearly come into force or partly become applicable. So when you think of the timing, one point that I think is very important is that the timing is set due to the course that we badly need better productivity, more investments, and more innovation in the EU. One number that I would like to mention is that since year 2000, the disposable income in the US has doubled compared to Europe. And we have about 20% lower productivity. So the timing is badly needed for EU. We need this kind of simplification. So, but especially about the AI Act, I think that one is a little bit, I don't know if the proposal is going to make any change. I mean, the timelines, I guess, is way too short to have everything put in place before it actually should be applicable in August. So, and 1.5 years later on, I mean, we don't even have the standards. They are not going to be ready in time, and everything needs to be speeded up desperately if this is going to make any change for the competitiveness and for innovation and so on in India.
Okay, so I do understand from you that timing is not only a matter of articulating legislations, but really running for a better regulation instead of deregulation in itself because of these overlaps and burdens that are difficult to read for businesses. And maybe Stefan, as a managing director of the institute, how we say VIDA or WIDA in German?
Yeah, VIDA.
VIDA is okay?
Mm-hmm.
From Berlin. What was also your take and for as an expert with people surrounding you, asking you for predictions, the $1 million or $1 billion question, will it happen and how can we anticipate our roadmap for 2026? What is your take? What is your take about that?
Yeah. First, thank you very much, Etienne, for having me with you here. First reaction was quite surprised. Like Lucas said, you can always dream about many things, but it's been bolder, this omnibus, than expected, but not bold enough. What are we talking about? Why are we talking about a better regulation, a better GDPR? Because it's necessary, because Draghi told us the need for reform, and because of the shortcomings of the GDPR. Luca talked about the unbalanced legal framework, and that's right. If you look at the risk-based approach, for example, that is only partially regulated in GDPR, and that's not enough in Article 24 and 32. We need more of this risk-based approach. Then there are obviously individual provisions that are misguided and misguiding, that doesn't work at all. Article 9, I don't have to say a single word about Article 9 GDPR because everyone knows that doesn't work. It's a French idea, but it doesn't work, yeah? And or if you look at Article 22, automated individual decision-making, that doesn't work in the field of artificial intelligence. And the GDPR is partly contradictory. Luca already mentioned recitals 4 and 10 that doesn't work together. We need a reform because the supervisory authorities, I lead one of those in Germany.
You know them from the inside, yes.
Yeah. That doesn't, we just don't have this uniform implementation of GDPR. This is not achieved, and not only not achieved in Germany, but in the whole Europe. The EDPB also exacerbates these issues about telling us that data is not an economic good or should not be an economic good, and overstepping the lines regarding DSA and GDPR. That's really calling for a need for reform. And the European Court of Justice well, you know what we have to expect from there. This is rather a problem than a solution. And so we are now in this fast-track procedure of the omnibus. We got a lot of time pressure from the AI Act that carries over to the other procedures. So, well, but we've got right now this window of opportunity, and we shouldn't wait for any digital fitness checks or anything like that. We should act now, and that's okay. That's a good idea of the European Commission to take this opportunity. And now we got the problems. The Commission doesn't want to lower the data protection standards at all, but rather maintaining them. So we're talking about a better regulation. And as I just mentioned, we have to talk about these issues like risk-based approach in the whole of the GDPR. And so, well, we have the European Commission in the driver's seat. From my point of view, they're quite well located there. They should have more powers in the implementation of GDPR. We should see and recognize that the supervisory authorities do not really create legal certainty. And that's a big problem. So last phrase from my side, the omnibus is a step in the right direction, but it needs to be bolder. It's quite bold, but not bold enough.
Wow, I think we have at least 3 to 4 punchlines in less than 5 minutes. One of them, I will take it and print it on my wall. But would you better trust legislative process in this context instead of waiting for regulators to combine, harmonize their positions, or the EUCG? Because it's in the balance of powers. The choice is made to come back to legislator instead of waiting for the indefinite period of time needed between 40 decisions from 27 countries plus 3 EUCG decisions on a specific topic. This doesn't make a consistent approach. Is this why you would prefer this idea of a reform?
Yes, I do. Just like you said, Etienne, we're stuck in a procedure that isn't perfect at all. If you look at GDPR, if you look at Article 97, there you got the task of the European Commission to evaluate GDPR, and they didn't do this at all since 2018. No really attempts to look for better regulation. So now we're in the procedure. Now we should try it. But as Luca just mentioned before, we only got time until July 26. Yeah, anything not approved by Parliament by July 26 will be out of the game. So this is really interesting and really, we're talking a little bit about dreams and science fiction, that this might come to a good end until the middle of 26.
Luca, time-wise, within the next 2 to 3 minutes, Luca and Carolina, would you have any other inputs to provide on these comments before we enter into some chapters of the omnibus?
No, I'd suggest to enter into the merit of what the amendments could be, and also talking about something else, something more, like Stefan said, and something bolder. I would say great is the chaos and heaven, and the situation is excellent. And so I think that the discomfort of the European Union can imply a new comfort, a new deal, new balance. And this is a great opportunity. Yes, I agree. The timing is an enemy in this case, but in any case, I would say, even if not by the summer, by the end of July, if we will not be able, again, this journey deserves our best effort, and I do hope that even over time, the European Commission and the Parliament and the Council will move further, and in 1 year, 2 years, we will reach a new framework, a new GDPR, and new rules that are more aligned with the time that we are living.
So thank you very much. Carolina, any?
Yeah, I could just add that something that is crucial is that everyone taking part in the negotiation, both from the Council side and of course from the European Parliament. I know it's a very problematic situation in the Parliament, but if we want EU to really move forward and we want to take care of our prosperity and our competitiveness, I mean, we badly need to do this, but that has already been said, but I just wanted to stress that. And this is, from our point of view, we don't look at this as a deregulation. This is to make better regulation. So really, we hope a lot for this, but of course sometimes you can only hope for the best.
Thank you very much. So this is the first episode of 3 sessions, today, next week, the week after. The idea for today is to provide the orientations, and therefore we will deep dive during the next sessions into the chapters we are just going now to cover, I would say, as kind of introduction to set up the scene. And maybe it's a good time for another speaker to enter the scene also. We have this GDPR big chapter where there would be a modification of the definition of a data, of a personal data. Mark Laser, as an academic and a legal consultant, could you please clarify this idea of changing a part of the backbone of the GDPR with the reform of what means a personal data under the GDPR?
Yeah, first of all, thanks for having me and for the informative introductions from the previous panelists. What I would like to say is, as a regulatory theorist, I think, echoing what has already been said, there's a bit of a regulatory overload in the GDPR, and that's now becoming a structural problem. So what I mean here is that it's become some sort of systemic choke point in EU digital regulation. It's doing too much work. It's too often in contexts that it was never really designed to govern. So this isn't a critique necessarily of the values or rights that come with the GDPR, but I think it's better looked through the lens if you critique it through the institutional fit and its enforcement capacity. So when I remember back in 2018, and even in the run-up to that, the GDPR was largely seen as being all we had to regulate digital technologies. And over the last 5 years or so, the EU has deliberately moved towards what I say is a polycentric digital order. And now we have the DSA, we have the DMA, we have the AI Act, we have the Data Act, we have sectoral data spaces, we have platform work rules. Yet the GDPR has remained this kind of legal trigger for every perceived digital harm, regardless of whether that harm is about identity, market power, manipulation, discrimination, or labor control. So what you get is kind of like a regulatory congestion. DPAs are overwhelmed by low-risk, high-volume cases, while structural harms persist largely untouched. And at the same time, as has already been indicated, there's this bureaucratic workload that is placed on actors regardless of whether they are suffering the harm. So the omnibus's reframing of the definition of personal data should be read as an attempt to correct that imbalance by kind of rescoping the material scope and not retreating from providing protection for the fundamental right to data protection. So it's not really about lowering protection, and it's about stopping one statute from being used as a universal proxy for sort of every sort of digital harm. And so the current debate, and seeing this as narrowing the definition of personal data, is actually misframing this as whether it's a binary choice between protection or data subject rights and deregulation to sort of promote and protect innovation. The real issue is about identifiability as a legal trigger and whether we're regulating actual capacity to affect people or some abstract academic theoretical possibility that might amount to what is personal data. So CJ case law, SRB in particular, already points towards a contextual control or relative understanding of identifiability. And the omnibus isn't inventing this, it's effectively codifying it. And I would argue that that was already the position in the GDPR, it's just making it more explicit. So a downstream actor that cannot identify, re-identify, or single out individuals cannot exercise the same kinds of power over them as an actor who can. And by treating all pseudonymized or indirectly linkable data as fully personal data has led to what I've said elsewhere is a definitional theater rather than enforcement clarity. And so the omnibus approach reallocates responsibility by re-emphasizing where the responsibility is in the processing of personal data. So high-risk actors with real identification capacity remain fully within the GDPR scope. Lower-risk actors that are governed through other regimes, for example, contractual controls, organizational safeguards, sectoral law, the AI Act. And crucially, this does not deny inference or profiling or sort of system-level harms like some people are claiming that it does. It insists that those harms should be regulated where they arise and not automatically forced into data protection law simply because data happens to be involved. So inference-driven harms is a problem of power and design and not merely of identifiability. Treating it as a privacy issue, which is the status quo, has not prevented it. It's actually normalized it. Now, the other thing that I think that the GDPR, maybe we'll come back to that in a second, but I want to just go on to kind of offer a counter narrative to some of the claims that are being out there about how this weakens the regime. And I think that's such a misnomer. I would even go as far as people are promoting misinformation when they make these claims, because narrowing the scope of personal data does not eliminate obligations. It simply redistributes them in the kind of chain. So where DPAs are no longer buried in marginal scope disputes, they can target actors with the real identification power, they can focus on structural practices, they can coordinate with other regulators. A leaner GDPR is actually a precondition for sort of a more rounded polycentric regulation. And the choice is not, as it has been named or as it has been claimed, about protection now or protection later. It's between symbolic protection and enforceable protection. And I think that's what the omnibus gets right. So I don't see the omnibus as, and I don't think other people on this call should read it as narrowing protection, but redistributing the regulatory effort in line to where the power actually sits. So the GDPR does work when it governs relationships between identifiable persons and information about them, but asking it to do everything has actually weakened the GDPR. And restoring some discipline is not leaving the job half done. It's actually a condition for making the GDPR work properly, I would argue, as it was actually intended. And that I think what happens here is that the GDPR and the EU doesn't doesn't lack digital regulation. I don't think anybody can make that claim. I think it lacks precision. And if every harm is framed as a data protection problem, data protection law becomes the law of everything and also the law of nothing. So the omnibus is imperfect, but the idea, the direction is correct. It restores the scope discipline. It sharpens enforcement, and it lets the broader regulatory stack in the EU do its job as it was intended. So the real risk isn't simplification. It's pretending that expanding the GDPR scope to everything has been working when evidence shows otherwise.
Okay.
Hopefully that answers your question.
Oh, yes, very much so. 40 years of harmonization within the EU, when we start with Sweden in 1974, France 1978, the 95 directive, and still not the same alignment on the definition of personal data, where we stand and wait for the next EU CG decision to know more about the day-to-day reality of these questions. Luca Bolognini, maybe you had another input to make on this GDPR chapter? With the long view you see, it comes back also to my question, is it a way to fasten our seatbelts in another chapter of regulation instead of waiting for judicial or regulatory powers to take their time not to solve the situation?
There is a need, an absolute need for legal certainty that we did not have, starting from the definitions during last decades, we can say, as you mentioned. The definition of the new proposed definition of personal data, I totally agree with Mark, is not about hindering data protection and taking out safeguards. It's about rationality. It's a reasonable and proportionate amendment, in my opinion. We have witnessed during all these years interpretations coming from authorities, academia, and also lawyers, which were and are absolutistic. The absolutistic approach to personal data definition. And now, and I would say...
You have an example in mind. We all have one. So maybe what is yours?
Yeah. Also, thanks to the new orientation of the European Court of Justice, as we all know, now it's starting a new era of relativistic and rational and reasonable
and context-based
definition and interpretation of what is a personal data. And I appreciated a lot also the proposed amendment relating to the sensitive data, the special categories of data which should be considered like that, with specific and clear boundaries, and sensitive only if they directly refer to sensitive information, to special information which can be risky, again not extending too much indirectly like it was done so far. And I see several other good measures in this digital omnibus concerning the GDPR. I don't want to deep dive because I know that you will have also a dedicated webinar to that. But let me mention that certain simplifications are very good. Of course, also the simplification and the rationalization again of the data breach and incidents management, the timing for them, and yes, I see several aspects that can be appreciated. What I would dream about. I can mention some points very briefly.
Please.
I would dream about better specifications in the principles, starting from the recitals and then enshrining into the principles apertis verbis certain elements like the need to rethink compatibility, the principle of compatibility of
purposes, yeah,
or to rethink and to improve the parts that concern the lawfulness conditions. For instance, clarifying once for all that in the legitimate interest, we should find the room. That is the point where we should find the room to balance data protection with other rights and freedoms according to Recital 4 and Article 52 of the Charter. And what I did not find, and I would be very happy to find in the omnibus in the next months, is a requirement, an obligation, actually an obligation for data protection authorities, and why not also for the DPB, two obligations. One is to conduct public consultations in a certain way, with the obligation to consider and to motivate, considering all the positions that are being expressed during the consultation. This is one relevant aspect, but data protection authorities and the DPB, they should have the obligation to carry out, before any decisions, to carry out impact assessments. You can mention, you can name them innovation impact assessments or
impact,
the rights impact assessments, something like that, because the impact of their decisions on other rights
and other markets and other questions
can be huge. Yeah. And so this is another point from my book of dreams. And to conclude, and not to steal time, why I'm mentioning certain points, and I can anticipate that as the Italian Institute for Privacy, we will also publish a positioning paper in the next weeks concerning these topics. Why it matters also to discuss about other proposals, because the journey is long, and now as experts, as stakeholders, we should try to propose something more, something even bolder to the policymakers. And so let us try to propose further amendments, further ideas altogether in order to strengthen this digital omnibus proposal. Why not? It can be a part of a dream. And so this is also an exhortation to all of us.
So this is a very nice wish list right after Christmas. And for this year, very good, I would say, intro to our next session that will take place on January 28th on the GDPR chapter of the Omnibus. Let's jump now, if we may, with the e-privacy chapter. Nathalie Lanneret as a public policy director for Criteo, and I would say a long-standing privacy specialist, even if you don't call yourself a data protection officer, you have a very good knowledge of these regulations. What about the e-privacy chapter of the Omnibus? What is for you at stake there, not only for your company, but with your vision as a public policy maker and advisor?
Thank you, Etienne. I hope you hear me well, and thank
Very
you
well.
for having me on this session. So as a short reminder, we're getting further into complexity here because we're not only talking about protection of personal data, but we're also talking about protecting the confidentiality of communication under the e-privacy directive, which is actually protecting the integrity of the terminal equipment. And what I tend to do here is a bit to mock a bit the reactions I had when I first read the Omnibus, because as you can imagine, as part of the professional associations, we had actually made a wish list, and we have been invited also to participate in some discussions with the EU Commission, for instance, the reality check or the GDPR meeting at the EU Commission, to actually voice our make our wish list. And so, of course, we had asked for these two texts to be merged and to stop having two different legal regimes applying to the same topic, but having one single regime under the GDPR, enabling actually interaction with the device to be able to benefit from all legal bases, meaning not only consent, but also, for instance, legitimate interests when these interactions with the device are actually low risk and are really needed just to ensure proper functioning of the device. And actually, when you start reading page 83 of the Omnibus, you start reading Article 88A, you're a bit excited because you see that actually Article 5.3 is now in the GDPR.
The cookie Article 5.3 of the
cookie Article 5.3 of the GDPR. You still have the two existing exceptions where consent does not apply because the placing of or the access to information on the device of the user is needed for proper transmission of communication and providing services. And then you're surprised, you say, wow, they even have added some new exception where you wouldn't need to ask consent. And so, I mean, of course, you see, well, these measures these new exceptions are a bit limited because it's only a first-party audience measurement, and security. And you continue reading Article 88A, and then you see also that they've tried to actually implement measures to reduce, the so-called consent fatigue. So now there would be a possibility for the user to refuse consent with one click. It would not be possible to ask a new request for consent for the same purpose. And if there's a refusal to consent, no new request can be made in 6 months. Well, for people in France, you look at this and you say, well, this is already what our data protection authority requires, but you think, well, in the end, it's good because it will bring more harmonization. Okay, so this is the first reaction. And then you continue to read, and you read until page 89, and you see something, and you realize that, wait a minute, actually, e-privacy directive, and in particular, Article 5.3 of e-privacy directive still remains. So
in parallel to a new provision.
So now I have 5.3 in GDPR when 5.3, or the placing or reading of information in the terminal equipment, is about processing of personal data. But at the same time, I have 5.3 under e-privacy directive when possibly there is no personal data. So the objective of this omnibus was, unless I'm mistaken, right, to simplify things. But now they have been fragmenting Article 5.3 into different legal regime that would remain in parallel. So honestly, I still don't really understand what they are trying to achieve with this, but I don't see any legal certainty whatsoever. Well, I mean, especially because they have left actually the e-privacy directive as it was, meaning that they have not added the additional exception to consent that they've added in the GDPR. So somehow now you can do more when you process personal data than when you process non-personal data. You have two regimes, one which depends on the GDPR, meaning that it is subject to the one-stop shop mechanism of the GDPR. On the other side, you have 27 regulators and a directive. Let's also not forget to mention that after the SRB case, we're not sure anymore really what is personal data versus non-personal data, and we still have not have clear and practical guidelines to actually be able to easily and with legal certainty to be able to define this.
For our audience, you are referring to this European Court's decision saying that a third party is not involved in the definition of personal data itself, and the complexity or reasonable means to find back if a data is identifying someone is regarded from the point of view of the company processing data and not from a theoretical point of view, which is a very good evolution. But as you said, not yet stabilized. We're not sure about the next decision from the EUCG, and we need consistency on this.
And just to be clear, before joining this webinar, I was on a call with my professional association, and we have 50 experts on online advertising, cookies, e-privacy directive article 5.3. We know it in and out, and nobody was able to figure out actually what is left under the article 5.3 of e-privacy. And actually, a number of member states have asked this question to the EU Commission. And the EU Commission has responded something really intriguing to me, is that actually this would apply to legal persons. Okay, but we are still identifying what are the potential use cases that are covered by this law. And so, when nobody understands what this law is supposed to apply to,
I don't experts.
Even some of the experts, yeah. I would tend to think maybe it's not a good law, especially when you are thinking about a law that is supposed to be able to simplify things. And actually, the change that has been made on this specific 88A raises more question and actually increases the level of legal uncertainty than actually, achieving the objective. So maybe I'll stop here, but I would have a lot to say also on automated choices, but maybe later.
No, thank you, Nathalie. Stefan, from a German perspective, but also another angle of vision regarding your background, what is your take about this e-privacy chapter? Is it an intermediary level of work? Some hope, but some further needs?
Yeah, well, first of all, I would totally agree with Nathalie. If you look at the Omnibus and at e-privacy directive, you only can talk about missed opportunities. This is not the simplification we had expected, and it's not the solution to migrate articles from e-privacy to GDPR and to have in the end, some fragmentation across multiple frameworks. That's not a solution. And as Nathalie just mentioned before, we're talking about a directive, an old directive, and we're talking about 27 member states maintaining divergent implementation. That is really not a good idea of the EU Commission to walk on with this structure, with the outdated 2002 e-privacy directive. And it's not only the problem on the level of regulation. We also got severe problems with the implementation. Look at the fragmentation of supervision of e-privacy on one hand and GDPR on the other hand. And so this is really that's not the time to think about amendments of the directive, about the deletion of Article 13 or 6 or 9. It's the time to come to a conclusion and to make this much less complex. Nathalie talked about the cookies, ADA. the proposal 88A GDPR, where you can only come to the conclusion we need a GDPR-aligned approach. And this alignment is especially important for smaller and medium enterprises and for smaller publishers and advertisers, because they are much more affected by this complex situation and by this consent first regime. That's not a good solution. Perhaps one more word regarding Article 88B and the requirement of the implementation of technical frameworks for transmitting machine-readable consent signals. This is not a good idea at all, because, well, you can always think about the level of regulation, but first of all, think about the experiences we made, even as data protection authorities, with these kind of technical solutions when we got no interoperable technical standards. They don't exist. Look at the German attempts about PIMS, the PIMS model. I know Luisa Specht-Riemenschneider will be angry if I say this, but there is no solution at all. We got no technical standards here. And so once again, this will all be a burden for small and medium enterprises and much too complex. So my opinion is just remove Article 88B in its entirety from this proposal. This would be a much better regulation.
Do you think it would be much better than in coming back to the status quo?
No, we're not. We shouldn't go back to the status quo. We should go, as Natalie already proposed, we should come to a solution with only one regime. Yeah, only one regime should rule, and this is GDPR. Full stop.
Okay. Yes, with the 6 legal bases, with the approach, with further purposes, consideration, with what is personal data, what is not, etc. Okay, so since it was not achieved during the e-privacy regulation discussion that was abandoned last year, I hope we can succeed now, because this success is part or not would be really part of the end result of this reform for the real rights of people, but also for the procedural aspects of it and the articulation between regulators and their powers. So far, you must be very rich to be able to comply with the 27 approaches of the e-privacy directive. And this is not the purpose of this luxury legislation. Thank you very much. I would like to soften the next chapter of the Omnibus AI Act, where everybody is looking at the clock, considering what is about to be implemented, what should be postponed, is there any stop the clock approach? And I would very much would like to welcome our next speakers on this. I don't know whether you are still there, Barry.
Sure, yeah.
Oh, nice to meet you, and thank you for being still there. I know you had lots of engagements in the same time, so can you please set up the stage on this AI Act chapter of the Omnibus, and where you're surprised, relieved, are you concerned? What is your hope for the ongoing discussion, which seems to be a speed dating discussion?
Well, the timelines that were initially set for the implementation of the AI Act were, I think, if you were being kind, you'd say recklessly optimistic. I think it's quite telling that the EU has missed pretty much every deadline it has set for itself in terms of the AI Act. So, when it came to the rules and prohibited AI systems, when those came into effect in February of 2025, we got the guidelines 4 days after they came into effect. And then with the rest of the documents we need, from the copyright transparency template, the guidelines on general purpose AI, code of practice for general purpose AI, these documents were either quite delayed or else we got them in some cases days before.
3 days before the deadline, yes.
Yeah. So, you can imagine what it's like trying to advise clients who are general purpose model providers on whether or not they should sign the code, and then working off drafts, knowing that things with the AI Act can change very drastically in the last minute, and as they always have since the inception of the AI Act. So one of the big things that the EU is going to miss in terms of a deadline is has missed the harmonized standards that it's felt are needed to ensure adequate implementation of high-risk AI, which is meant to come into effect in August of this year. But we don't have those standards in place. And there's a lot of political toing and froing and upheavals in terms of getting those standards in place. So, we don't know when they're going to come. So I think off the back of the Draghi report, and I think we have to consider the fact that the JD Vance speech in Munich, for better or worse, played a part in it as well. Like what we've heard from the other speakers, the EU is trying to remedy some of that reckless optimism with the Digital Omnibus Package pertaining to AI. Before we get to the stop the clock thing, it's worth outlining some of the other changes that were being made. So, for example, with the extension of the SME regulatory privileges, initially that was only applicable to smaller companies, but what's been changed is that the regulatory benefits that were originally reserved for micro, small, and medium enterprises are extended to small mid-caps. So these are enterprises with up to 1,500 employees. Now, this is being done simply by the definitions of SMEs and SMEs are added to Article 3, and the other modifications are made. For example, simplifying technical documentation, proportionate document management systems and things like that, and lower administrative fine brackets. Now, the reason that this is being done is trying to prevent that cliff edge effect where high growth companies can suddenly face massive compliance burdens and large enterprise penalty risks the moment they outgrew the standard SME definition. So I think this supports mid-sized European innovators, and it's really favorable in terms of building up that EU ability for innovation that we look to, and we look across the Atlantic to Silicon Valley. Then going out to the explicit legal basis for AI bias detection and correction. So what's being changed is that a new Article 4A is being introduced, and that's giving a clear legal basis for processing special categories of personal data strictly for ensuring bias detection and correction in AI systems. Now, I think there's a strong argument to be made that, these companies already were meant to be doing bias monitoring and bias correction. I can't even begin to imagine how you could do that without processing special category data. I would certainly have thought that there is a strong, legitimate interest. But then again, if consent is the way to do it, then it would have had to have been done that way. So this is kind of fixing that discrepancy by introducing that specific legal basis. So this...
may I ask you a kind of a schizophrenic question? How can you manage having these issues in front of you, being a member of the AI Advisory Council of the Irish government, but also a lawyer advising companies in their projects? Would you prefer, as an advisor, to not to enter into too much details in your answers because it's not certain enough, and as an advisor for the Irish government, push for any postponement of these questions or push for any clarification? With your role providing advice, do you think we need these clarifications to happen before applying these rules? Or could we do it without this AI Act chapter?
I think we've been doing it without. I mean, in terms of my role as a member of the AI Advisory Council in Ireland, that's more issue specific. So it's not that you're like the Attorney General advising on all things AI, you're very specific. If there's a specific issue that comes up, you advise on that specific issue. So, for example, I chaired the working group on the impact of AI in the creative sector. And I'm specifically dealing with the copyright issues. So, there's collective responsibility for it, I guess, is that like the advice isn't coming from me, it's coming from the advisory council. I sit in the advisory council in a personal capacity, not representing my law firm. And obviously when I have my law firm hat on representing clients, it's a different matter. But I think for all member states, I think they're on the same boat as all the companies, because like I can speak to the high risk AI issues and the stop the clock mechanism. I'm sure it's the same for all of you, but our advice to clients is that, well, we don't know if the Digital Omnibus Package is going to pass.
You mean we are absolutely useless? Is that what you mean?
Are we?
We are absolutely useless because we don't know.
Well, like it's I've used the term Schrodinger's omnibus, because it's both delaying and not delaying the AI Act at the same time. Because on the one hand, the proposal is seeking to delay the AI Act, but everyone is acting like the omnibus doesn't exist, because you can't just get, okay, we don't have to work anymore in our high-risk AI implementation, because the omnibus is delaying it. But there's issues. First of all, the omnibus may not pass in time. I'd be surprised, actually, if it passes on time. I think it's optimistic, the timeline they've set for themselves. But then, like, what if it didn't pass in time, but then the omnibus came in say, October? Like, what about those few months where all these companies weren't in compliance with what the law is, where you'd have high-risk AI, and then it's delayed? Like, would there be retrospective legislation passed giving, a pardon to any issues? And there is European law precedent for that, which I think it would be embarrassing on the world stage to be fudging the issue like that. And then, so I think it's tied to the stop the clock mechanism is tied to the European Commission deciding that there's adequate harmonized standards in place. So it comes down to, like, the firing pistol goes off when the European Commission decides it goes off, which could be any time. And then you have 6 months to comply. There's a hard deadline of December 2027 for Annex 3 high-risk AI systems. So, like, if the Commission decided that, okay, now you have the standards in place, and they decided that in September of 2027, you'd have 3 months to comply. So the thing is that we have the current law. The current law is very clear. High-risk AI will apply from August. So our advice to clients is we'll continue with your high-risk AI compliance frameworks. And in terms of MSAs that we're drafting and acceptable use policies that we're drafting, all our clients want to deal with the high-risk AI elements that are involved in that area. So, commerce is going on as though the Digital Omnibus proposal hasn't even arisen. In terms of member states, well, member states are on the same boat. So member states are there, they're trying to get their national AI offices set up. They're trying to do, the member states that are doing a transposition of the AI Act, they're trying to get that in place, trying to figure out what the regulatory framework is going to be, who's going to be responsible for what. Are member states meant to go, oh, well, you've got the Digital Omnibus Package, we don't have to worry about that anymore? No, member states are in the exact same boat as companies. They have to continue acting as though the Digital Omnibus never happened. So we have this proposal, and it's both delaying the AI Act and it's not delaying the AI Act, because everybody's acting like the AI Act won't be delayed. So then what's the point? Because then by August, if you're being sensible, most companies are actually going to have broad compliance with the high-risk AI obligations. And then we're probably not going to get the Digital Omnibus passing, if it does pass, until late spring or early summer. Like, I would say at the very earliest, maybe May, which is just a couple of months away. So we're doing all of this for the sake of it 2 months, because otherwise the companies should be doing this. So, in that regard, doesn't make sense. Now, if you're a very big AI company, any breathing space you have where you don't have to comply with massive regulatory obligation, you're not going to turn your nose up at that. So fine, you did your high-risk AI applications, but if it doesn't apply for another year or two, great, happy days for you. But I question its usefulness, and it does make the EU look capricious. It makes the EU look undecisive, and it does show a lack of leadership that we really need, given the geopolitical situation currently. Now, I'm sure you can tell I could talk about this for a very long time. I'll pause here, but I'd be happy to take any other questions you have.
Okay. Yes, lots of things to say about leadership, but Theodore, you have such a, I would say, profound approach of the overlaps between regulations and also this chapter of the AI Act. What is your take about the content and the time frame of this?
Yes, basically, I think that if we focus on the AI Act, the Digital Omnibus concerning the AI Act, it's a big confession, admission of errors, of complexity, of things that have been rushed, of things that have been made very, very, very complex. When it comes to the GDPR, I'm very critical about some of the reforms, especially this so-called argument of the need to codify what the Court of Justice said on personal data, which I entirely disagree. It is for the legislator to fix the rules, not to codify how the court interprets a specific interpretation of the rules. But this is another chapter, and this has been discussed earlier. But when it comes to the GDPR or the e-privacy, we can agree or disagree with the proposals. We heard a lot of good criticism before by my colleagues, but at least it makes sense. You have instruments that are have been adopted years ago, and you have seen problems eventually during their application, and you might want to do some fixes for these problems. But for the AI Act, it makes no sense. This instrument has just been adopted. It has just been adopted. It has been adopted in a very, I could say sometimes hasty way. It's an extremely complex instrument, not only for all businesses, not only for lawyers, but also for academics who are studying this. 113 articles, 12 annexes, 144 very, very dense pages as published in the official journal, not to speak about all the need for additional actions in order for this instrument to become
concrete.
Standards, guidelines, codes of conduct, and the scary bureaucracy. We have done a lot of work in the AI regulation chair, and you can check our instruments to see what huge delays and problems we have just for the bureaucratic part of, and you can read an article by my colleague Shade Pinto. So, not to talk, of course, about the very hasty regulation by the AI Act of general purpose AI systems, which, ChatGPT almost torpedoed the risk-based approach of the AI Act. And I think that what was finally found as a solution, including this already outdated compute threshold that curiously, the Digital Omnibus has not touched. This shows us that probably we moved very, very fast with the AI Act. So when it comes, of course, there are a lot of admissions that this omnibus, when it comes to the AI Act, is a kind of sound of the Brussels effect hitting the wall of implementation. And if you see, for instance, the standardization gap, Barry said that the deadlines for high-risk systems and for the adoption of the standards was recklessly optimistic. I entirely agree. I could use even stronger terms. But this shows an admission by the Commission that we cannot set such quick deadlines. Especially the standards here is not about things that exist for years, like toasters or whatever. When you can fix the standards, there is a real difficulty, to create these standards, and it has to be done in a good way. It is impossible to expect from industry, especially from small companies, to comply with non-existent technical specifications. It's a real legal impossibility. We have the admission of the proportionality error that Barry also mentioned, which is that the initial act focused on SMEs, but ignored all the small mid-caps. The EU admitting it nearly strangled its most promising scale-ups in the cradle. We have other admissions also in this, that things have been done wrongly. So, of course, while I'm very critical, what is interesting is that while I'm very critical about some proposed standard GDPR, I think that the most important issue, which is this delay, I totally agree with all of the things that Barry said, but somehow this delay was absolutely necessary. I think just to make a few comments about this delay, which is the most important aspect, the delay for the high risk, the implementation of the high risk systems. The delay should be conceived as precisely an effort to avoid the compliance cliff. As a useful transition period, companies should definitely keep working on this, but this should not be considered as a reason to relax things on a series of issues. First of all, not relax the setting of standards. The idea is not to mark a pause suddenly on the setting of standards. That I think it's extremely important, as we know that the standards are developed by the industry, and some NGOs have criticized this by saying that the industry might use this after all, in order to further scale down the AI Act. But this work on standards must continue, must intensify. It's a very difficult work, once again, but this should not. We need the standards, so this transition period is very welcome. There is another issue, which is the risk that companies might consider that there is no need to work actively anymore on the implementation. I entirely agree with Barry about the fact that no, on the contrary, they should keep on working. There are a lot of things to do. They should take advantage of this transition period and do this work. And I think that I could give a lot of examples that implementation already of the standards of the AI Act could provide a competitive advantage. There is a huge competition, and of course performance of AI systems will be a very critical aspect, but trust also will be an extremely critical aspect, and companies that will move as soon as possible in order to implement the basic components of the AI Act could claim this trust. I want to criticize very heavily the stop the clock uncertainty, which was introduced by the Commission, which is precisely this compromise, always these horrible compromises. And the fact that in order to push for December 2027 or this August 2028, the high-risk systems of the AI Act, the compromise that the Commission introduces is that if the standards are developed before this, then eventually, this we could move forward more quickly with the implementation of this. I think this is a huge mistake because this creates a total uncertainty, and I think that the Commission should really abandon this before being adopted. Industry needs to have very, very clear deadlines, and we cannot tell them, as Barry said, that in 3 months you will start working on this. And concerning more generally the legal uncertainty about when we definitely need this delay to be acted. So if they need to separate this and to adopt just this delay and continue the discussion about other issues, there are very important issues such as the removal of the registration requirements, where there also we see a kind of admission that it was a compromise, it was the price to pay for giving the possibility for high-risk systems to say no, that after all they're not high risk and we have to register, but somehow we realize that this could create a huge bureaucracy that could crush the system, and we introduced this. There are a lot of criticism, which sometimes are justified. This does not mean, of course, that the industries would not need to document this self-assessment, because the regulator can ask later. But I think that as long as we continue eventually the discussion, some more tricky parts, the easy parts, including the delay, should definitely be implemented on time, so that there will be a perfect legal certainty. Even if you have to separate this, there must be real clear certainty for all industries that should continue the work on the meanwhile. So
Thank you.
this is what I wanted to say, and I think that it is very important to give clarity to all stakeholders in Europe concerning what is already a very, very complex regulation. We should not make also the deregulation phase very complex.
Thank you very much, Theodore. This is a wonderful introduction for our next Tuesday's session that will be dedicated to this chapter. We will enter into details. My only take on that is that we were the first ones that were adopting a comprehensive legislation. I'm afraid we'll be the last ones to understand it. But hopefully, next steps will be providing some clarification. So I know it's time for our audience to maybe leave us. It has been very intense. I apologize for the speakers and panelists that stayed until the end, but I'm afraid we don't have more time to comment for today. This is not the last chance, because we'll meet at the same time next Tuesday on the AI Act chapter, after this very profound and I would say bold introduction to the omnibus, split it in 3 episodes. So thank you very much for joining today, and hope we'll be with this discussion next Tuesday and the Wednesday after. I wish you a very nice day, and thank you again for joining us today.